taken care of. We don't have to
Yeah,
worry about
Zoom
that.
is active as well.
So, folks, we're going to get started. The more people filter in, they're going to get filtered in. So the purpose of today's presentation is the human rights and residential listing process. If you do residential listings for your clients, this presentation is unbelievably important. And let me explain to you why. I'll get into it during the presentation. I currently represent 15 realtors before the Human Rights Tribunal on discrimination cases based off wording and verbiage that is commonly used in real estate listings. So the purpose of today is to give you some ideas of what may be discriminatory, but the main takeaway that I want you to take away from today is that the limitations at the Human Rights Tribunal is a 1-year limitation period, and it's so important for you to keep documentation. Because most of the time, these claims for discrimination can be defended or even resolved based on good documentation that shows that there was no discrimination in place. What's important to understand is the Ontario Human Rights Code is what we call quasi-constitutional legislation. It's second only to the Constitution of Canada. It overrides every other piece of legislation. Okay? In order to be discriminated against, there does not have to be active discrimination. In a lot of cases, discrimination can simply be that the wording of your ad made somebody feel that they could not apply. That in itself could be discriminatory. And I'll get into some of those things during the presentation. My name's Dan Schofield. I'm the current interim managing partner of SFG Paralegal Services. I have brought with me Sharda Bikram Singh and Victoria Marr today. They're both paralegals in my office. We are going to hang around and answer questions for you after the presentation. It doesn't necessarily have to be about human rights. Happy to answer other questions for you. Our office does human rights matters, landlord and tenant board matters, and I represent realtors in front of RICO. So it's all questions that we can answer for you. So first of all, what's a human rights code? This is what we're going to discuss. What's a human rights code? What does it say? What's a legal test? Frequently seen questions that we have from either realtors or landlords or people who are working with residential tenants. What a discriminatory rental ad may look like. Possible discriminatory information on a rental application. This is really important. We've actually talked to OREA about changing some of their application forms. They haven't really shown a lot of interest, but it is something that you as realtors, there may be some amendments that you want to make to the forms yourself to avoid any possible accusation of discrimination. Discriminatory behavior once a person's a tenant, we're going to discuss that briefly. The points mentioned today are not an exhaustive list, meaning that there could be other issues, so we really urge you, if you're ever in doubt, to contact a legal representative and just ask a question. My office, as long as the privilege isn't abused, you can always call us for 5 or 10 minutes to ask us a question. We're never going to charge you for that. Okay? Unless I get a call every day, and then maybe we'll have to discuss it. This presentation applies only to residential tenancies, even though the Ontario Human Rights Code applies to services and contracts and other such things. This is only in regards to residential tenancies. And the main takeaway from this presentation is that when leasing the property, you should keep all of your records for at least a period of 1 year. A good example, one realtor that I'm representing right now, based on everything they've said to me, there was no discriminatory decision made, but he deleted all of his emails. He said, "Oh, I'm done with this. I don't need them anymore," and he deleted them. Had he had those emails, it would make our life much easier. Okay? So nothing said today should be seen as legal advice. This presentation doesn't create a client relationship. If you require assistance, you can either speak to us or you can call the Human Rights Legal Support Center or the Law Society of Ontario Referral Service. We're not able to provide specific advice during this presentation, so that may look like, if you have a current situation, maybe generalize the question a little bit and not speak specifically to what you're currently going through, but just ask general questions around it. This presentation is available. I have it as a PDF. I'm happy to email it to people after the presentation's done. So what's the Human Rights Code? It's a law of Ontario. It gives people equal rights and opportunities without discrimination in specific areas. We're going to talk about housing today. The code prohibits discrimination on harassment based on race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, this is why I've written down, gender expression, age, marital status, family status, disability, and receipt of public assistance. The Human Rights Code, like I said, it's quasi-constitutional. And the code also provides protections in regards to services, contracts, accommodations for person under the age of 18, employment, vocational association, sexual harassment, and reprisal. Well, again, we're not going to discuss a lot of that today. We just don't have the time. So what's undue hardship? You're going to hear me refer to undue hardship several times during this presentation. Undue hardship is your obligation within the leasing process, or your client's obligation within the leasing process, to accommodate to the point of undue hardship. What undue hardship means is what are the costs? What are the costs of outside sources of funding, if there's any, and any health and safety requirements to accommodation. Nothing else is considered. Okay, so what's discriminatory advertising? So I recently updated this post. This post, oh, this is kind of blurry. I don't know if I can make it.
Yeah, I was just going to say, I was going to ask if I'm the only one that can't read it.
Yeah, unfortunately, because it's an image embedded into a presentation, I can't make it any clearer. But I'll read it off the computer, so it's a little more clear for you. I recently just updated this presentation. This was the first ad that I found. Discriminatory ads are not necessarily difficult to find anywhere. Kijiji, Realtor.ca. So this ad reads: immaculate townhouse with open concept layout, hardwood and ceramic flooring. Throughout except bedrooms, stainless steel appliances over 2,000 square feet, with attached 2-car garage, double driveway for 4 cars, laundry on 3rd floor, functional basement size and huge windows, 9-foot ceilings. Everything sounds great so far. Balcony minutes to 404, plans on all amenities, school information, Victoria Square, PS, Richmond Hill Green, all bright light features, window coverings, fridge, stove, vent hood, dishwasher. All that sounds great. Then it says, looking for AAA plus tenants, rental app, employment letter, credit checks, and $300 key cleaning deposit. Can anybody pick out the discriminatory part of that ad right now?
AAA. Looking for AAA.
It's one of them.
Adults only. Didn't it say
Didn't say that,
adults?
no.
No,
What did it say?
it's an employment letter.
How was that discriminatory?
That's what we're going to get into.
Mhm.
That's how easy it is. Okay.
We all laugh
Yeah. Even
That's-
AAA is on every single ad.
So I
That's why you're all
pre-warn
here.
I pre-warn realtors when I'm giving this presentation. Initially, it's going to sound absurd. Initially, you're going to have a gut reaction that it's simply ridiculous. I would ask that you pay attention during the slides to understand why some of these things are discriminatory, so that you can understand how to get around it in your ads, but also more importantly, so you can keep records and indicate and make sure that nothing you've done will create a problem for you later. I've not made up any of the information in this presentation. The information in this presentation is right from the Ontario Human Rights Code, right from the Human Rights Resource Centre white paper on discriminatory ads in housing, as well as discrimination in housing. So this is all based on existing case law. This is all based on stuff that has already been before the courts. Okay? So, when listing rental opportunities, landlords may not exclude people identified by the code. For example, a phrase in an advertisement such as suits a working person may indicate that people who receive social assistance who are unable to work due to disability or other code grounds are not welcome and need not apply. Okay? Other forms of inappropriate advertising include statements that the building is adults only, because in order for it to be adults only, it has to be a senior's residence.
So if it's a senior's residence,
It's fine if it's a senior's residence. Adult lifestyle, right? Not suitable for children, suitable for a single person or couple, working people only, professionals only. It is not required that someone apply and be turned down. It is enough that they feel they could not apply based on the wording of the advertisement.
Would the
Is-
word preferred fix all that?
No,
Okay.
right?
Solidifies the term.
Because, and let me explain why. The reason preferred wouldn't fix it is because you're still indicating to somebody that they can't apply. So if, let's say you have a 2-bedroom unit for rent,
Mm-hmm.
and you say suitable for single person or couple, or prefer single person or couple, and a woman, single mom with 2 kids, applies and gets turned down, first of all, they're going to say, you discriminated on me based on family status, because even though I applied, I have 2 kids, and your ad said you preferred another type of person. And the second thing is, they don't even have to apply. They just need to take a screenshot of your ad. And to show you how serious this is, we turned down a client about 1.5 years ago. This woman had 26 matters before the Human Rights Tribunal. Okay? They were all for discriminatory rental ads for apartments that she had never even applied for. She's on ODSP. Human Rights Tribunal awards don't go against her income. And she knew that most of these cases would settle for $5,000 or $6,000 at mediation. She wouldn't be taxed on it. It wouldn't affect her ODSP benefits. But the realtors on the other side, I didn't represent any of them. I didn't take the client, just so you're aware. But the realtors, based on my experience, all spent $5,000 or $6,000 in legal fees to get to that point, to settle for another $5,000 or $6,000. Okay, so when you say things like preferred, you are still saying somebody identified by a code ground need not apply. So it's best that your rental ads be as neutral as possible.
Dan, did those realtors also face complaint with RICO?
They didn't, because this woman wasn't interested in the complaint because she wasn't going to make any money from the complaint.
Okay, fair enough. I just wondered.
But
For everybody.
theoretically, a RICO complaint in a legitimate bona fide case of discrimination could be filed. This story is a bit of a horror story. I don't like telling it, but I will, just to give you an example. I represented somebody who was an applicant in this particular case. The landlord hired a realtor to sell the property. The woman's son was autistic. She asked for accommodation in regards to hours of showings, saying, my son who's autistic does not do well with disruptions in his daily routine. Please show the property to prospective buyers when my son is not home, and gave a schedule of when the son would not be home. The realtor said, the act says I don't need to give you this notice or accommodation, and my rules from RICO say I don't need to give you this accommodation, so I'm not going to listen. It culminated about 10 showings later of this small 10-year-old boy effectively banging his head into a brick wall whenever somebody came into the property. Right? That realtor was the subject of a complaint. Okay, rightfully so. What I'm trying to do is to put you guys in a situation where you can avoid frivolous complaints. Where you can avoid complaints that have maybe merit to the person who's filing it, but really aren't going to go down the road much further. That's the purpose of this presentation. So, discriminatory advertising that targets household with children may be more suitable. Where a landlord is attempting to discourage denying applications for families with children, they may use specific euphemisms, such as the building is a quiet building, it's not soundproofed, geared to young professionals. When using statements above, coupled with a refusal to rent to a family with children, it may indicate a discriminatory attitude. Section 13 of the code prohibits publication or public display of any notice, sign, symbol, emblem, or other representation that indicates the intent to discriminate. Signs that include phrases such as the ones set out above may be in breach of section 13 of the code. Right? It may very well be that your client doesn't want a family of 3 living in their basement bachelor apartment. And that may be something that can be dealt with in the screening process. But it's probably not something you want to put in the advertisement. Screening phone calls. Again, this is one of those ideas that you're just going to think of as absurd, but Telephone inquiries may provide information about a prospective tenant that a landlord may use for discriminatory purposes. When calling to ask about a rental property, a prospective tenant will be required to provide their name, which may reveal characteristics about their identity. Telephone communications will indicate things such as the presence of an accent. Landlords may be able to screen out prospective tenants simply by saying, after they hear the tenant speak, oh, the unit's already rented, we're not interested in renting to you anymore. The practice has been referred to in law as linguistic profiling. And tenant screening of any kind that targets people based on code grounds is contrary to human rights principles and may result in a claim being filed with the Human Rights Tribunal. To suggest that you shouldn't speak to prospective tenants on the phone is just not feasible. What we usually recommend is that you keep notes, right? Ask questions that are relevant. Don't ask a person where they're from, even if it's in simple conversation. Don't ask a person how old they are. Don't ask a person how many kids they have. Don't do anything that could lead to a code ground. Simply take notes and analyze the substance of the transaction, right? So what would that look like? Where are you living now? How much do you currently pay now? What size of the house are you living in now? If somebody's saying to you they're coming from a 4-bedroom house where they pay $3,000 a month and they're looking to rent the 2-bedroom basement apartment, that may indicate a red flag for you that's not a code-based red flag. It's something's wrong here. Why would somebody go from a 4,000 square foot house to a 1,000 square foot basement? Something's not indicating properly. Keep notes of it. We live in a first party consent country. The case, not in my presentation, is a case called R.V. Dwart, which was a BC Court of Appeal case that said, you do not have to let other people know that you are recording a phone call. As long as you are an active participant in the phone call, you can record it without notifying anybody. So a lot of realtors that we deal with now, they download an app called Automatic Call Recorder, ACR. It's on the Google Apps, the App Store or iPhone Store, and you can record the conversation with the person that you're on, and it saves it to your phone or to a cloud, right? So that gives you a little bit of backup if you're talking to somebody to determine, you know, they say, well, oh yeah, well they had a phone call with me and they asked me all these questions in the phone call. You can say, no, I didn't. Here's the phone call that the person is referring to. Listen to it. I did ask nothing inappropriate. And when they say, well, you can't record me without my consent, yes, you actually can, as long as you're an active member. So I think I heard your name was Samantha?
Yes.
Great name. My wife's name is Samantha. Mm-hmm. Okay, so if Samantha is on a phone call, what's your name?
Danielle.
Danielle, I'm Dan. Danielle cannot record it, okay? Because Danielle is not an active participant in that phone call. But if Samantha is on the phone with, what's your name?
Liz.
Sorry?
Liz.
With Liz, Samantha doesn't have to tell Liz she's recording the call, because they're both active participants in the telephone call.
So just take note, you may be recorded anytime.
Well, I always say, you know, talk with your friends, but whenever you speak on the phone or send an email, act like it's going to be evidence in court. Right? So, application forms. This is the one thing, like I said, we spoke to Aria, they haven't really moved on it, but you can protect yourself as realtors. Some housing providers, real estate agents, agencies hired to screen tenants may engage in practices that are designed to screen out certain people identified by the code. An application form that asks the person's source of income may reveal that the person is receiving social assistance, or that a person is unemployed due to the presence of a disability. A person's name, while necessary for information, may indicate prospective tenants' membership in a specific racialized group, or identify them as a practitioner of a particular creed. Creed, for the code purposes, is also religion. Application forms that are often used to ask age of prospective tenants, which the Human Rights Tribunal of Ontario has already found to be a prima facie case of discrimination. Application forms may also be used to determine the number of children in a family. Where landlords ask such questions, the onus will shift to them to show that there was no discrimination. So the Human Rights Tribunal is a bit of an oddity when it comes to court. Usually in a court case, if I'm suing Danielle, I, as the plaintiff, have to establish on a balance of probability that I have a reason to sue Danielle. At the Human Rights Tribunal, if I sue Danielle, the onus is a reverse onus tribunal, so Danielle has to prove that she didn't discriminate based on my evidence. Okay, so children, for the most part, aren't covered under overcrowding bylaws. Children, for the most part, are not going to be signers on a lease. Children, for the most part, are not going to have any active day-to-day role in the rental. Is it really information you need? Now, if you're renting a one-bedroom apartment, a bachelor apartment, there's probably other ways to determine if children will be involved in the mix without flat out asking how many children do you have. If you ask somebody their age, there's currently a case before the Human Rights Tribunal of a couple that were both 20 years old. They applied for a residence in downtown Toronto and were turned down specifically because they were too young. So asking someone's age, anything that identifies creed, anything that identifies a source of income, okay, can be discriminatory. If you ask the question, the onus will shift to you to show that that question had nothing to do in your decision, right? So one of the things that's discriminatory is receipt of public funds. So if you're leasing a basement apartment for a client and the basement apartment is $1,500, you only need to establish that the tenant makes enough money to pay that $1,500. You don't need to establish where it comes from. This is just an application process. There's still a vetting process that will need to take place. There's still a credit check that's going to need to take place. There's still a reference check that's going to need to take place. This is just the initial part of the application. So I always advise, think about the information that you really need. If the person says they make $2,500 a month and the apartment is $1,500 a month, that's the information you need. Where the money is coming from is irrelevant, whether it's work, whether it's child support, whether it's ODSP, whether it's OW, where that decision is coming from is irrelevant. As long as they show that they have the income, which by the way, if you've accepted their application on a conditional basis, you can now ask for proof of income. It's just the initial application phase where people get into a lot of trouble.
Can I ask a question on that?
Absolutely.
So when we do an agreement to offer on a lease, usually in the brokerage remarks, when you send in the offer to lease, they've already asked for the employment letter, the rental application, and the credit score. Is that, like, they shouldn't even be asking for that right away?
The employment letter is a definite no.
Okay.
The credit score and other things, sure, that's fine, as long as it's not used in a discriminatory way, which we're gonna get into in the presentation.
The rental
Right?
applications
Yeah.
also include like all people that are gonna be living there with their ages.
Look, it's a balancing act, right? So what I mean by that is to say, of course, every decision you make should not be discriminatory. I mean, none of us want to be discriminated against on a daily basis. If your client says, look, I need the best shot at getting this place, so here is my employment letter, here is the information about my kids, if there's all of these things that are happening, and you submit that, you're not doing anything wrong. First of all, your client's voluntarily giving you the information, and has told you, use this information to secure something for me. Okay? If you
They're asking for it.
If they are asking for it, technically it is or could be discriminatory. But again, it's a balancing act. The problem usually comes in when a person's rejected. And the reason that they are rejected, which I'll get into in this presentation, has to do with their employment. Oh, they haven't been there long enough. They, whatever the reason might be. Right?
But see, you could also, if they choose not to comply with the application, that could also set off a red flag for the landlord thinking, well, this person's gonna be difficult
Well,
because they don't want
I think, just to give you some background on me, I was in sales for 20 years before I started doing this, so I think that a lot of that will come in the framing of how the offer is presented, right? if you say to the other realtor, look, we had this presentation in my office, I maybe get this guy into your office, but these things could be considered discriminatory. And I provided you all the information. And if you like what's on there, I can give you more detailed information down the road. But let's see if we can get this done based on just the income is 10 grand a month. Do you really at this point need to know where that income's coming from? There's going to be an income verification, right? You're not just taking my word for it, right? So some of those things can be done, but again, it's the symptom of it's the weighing, right? Like when I got divorced, I had to rent at first. Yeah, I knew that every single thing these people were asking me was discriminatory. They asked me, if I had kids and how much I made and what my I knew everything was discriminatory, but I need a place to live.
Well, that's the other,
Right.
So, in my case, I complied because I needed a place to live, right? If I had chosen to do something about it later, I could have. I mean, I litigate for a living. The last thing I want to do is file my own application, right? But I have a choice. I'm just giving you possible things that can happen. And in today's world of Facebook, in today's world of Instagram, I don't know how many of you are on Landlord and Tenant Board Facebook groups, but these people are getting advice from 26 different sources. They are much more educated in residential tenancy law than some lawyers and paralegals that I know, and they will come after you. It's just a symptom of the time that we live in. So let's just protect ourselves as best we can, right? I'd also like to be clear that asking for employment letters, while they are technically can be considered discrimination, on its face it's not necessarily discrimination. So, for instance, if the person is employed, it's not discrimination. It's only discrimination if they're on OW or ODSP or OAS or CPP, right? Then it's considered discriminatory because they're a member of a protected group. But if it's an employment letter and the guy works at Microsoft, it's not discriminatory, right? So I'm just giving you some guidance on what might be considered discriminatory so you can use your best judgment as professionals to determine how you want to move forward with something, right?
And if you're in the landlord business, maybe in one property you can have a certain type of tenant, in the other property you can't have a certain type of tenant.
My ex-mother-in-law owns 6 apartment buildings in Aurelia.
Yeah.
One of those apartment buildings are beautiful 3-bedroom condo style units, and the other one are 1-bedroom, or not even 1 bedroom, they're bachelor apartments that rent for $600 a month.
Yeah.
Obviously, well, I'm not gonna say obviously, but most likely the apartment that's renting for $4,000 a month is not gonna get a lot of ODSP applicants.
Yeah. No, but I'm saying, like, for example, I deal with a lot of landlords, and there are certain properties we can have kids in the house. There are certain properties, even though they're both 3 bedrooms, you can't have kids in the house because there's another tenant that's down there. So it's not that you're being discriminating; you're just trying to avoid any future problems.
Oh no, that's still discrimination.
So what about my tenant?
Listen,
you know what I mean? Like, you're trying to avoid
I'm going to tell
issues,
you how.
right?
Let me tell you how an adjudicator is going to look at that. An adjudicator is going to look at that and say, "It's a 3-bedroom house upstairs.
Yep.
You live in the basement of that house. Do you not expect there to be noise from the upstairs tenant?"
So, okay, we have a situation where there's a lawyer living downstairs. It's an individual been there for 15 years. You have a 3-bedroom house upstairs. So now the lawyer's working, especially with COVID, he's working from home a lot now. So we are looking for somebody very specific that's working from 9 to 5, that's not in the house, right? Doesn't have any kids or anything like that. Then I have another property where it's a triplex. We've got 3 kids upstairs.
So I can't give you specific legal advice, but I'm going to say this.
No, but if I was to
Okay.
go to court, then I can show that.
Hold on.
Yeah.
I can't give specific legal advice, but let me cap off the question with this.
Yes.
The Residential Tenancies Act, as well as the case law within the RTA, which isn't really something that we're talking about today, it's something I'm coming back to talk about.
Yeah.
There is thousands of cases that say, yes, this person's reasonable enjoyment of their unit was affected, but they live in a house with multiple people, and they can't expect silence. The fact that he's a lawyer and he works from home is really kind of irrelevant to the equation. Now, if you can find somebody that meets your needs and it's not discriminatory in how you found them, fill your boots.
So I waited 3 months. I didn't rent it out because I'm looking for the right tenant. I took a meeting on the
Okay,
rent.
but the point is,
Yeah.
right? If somebody were to come to you and they checked all the boxes,
Yeah.
but they had kids,
Yeah.
and you said, "Well, sorry, I can't rent you. You have kids, and the guy downstairs may have a problem," you would then potentially have a problem.
Okay, then my last question that you can carry on is, then do you have to disclose the reason for refusal?
So you don't have to, okay? But keep in mind, remember what I said, reverse onus tribunal, right? So if they check all the boxes except for kids, you're going to have to to justify the decision at some point. Maybe you don't have to tell them, but you're gonna have to tell an adjudicator at some point.
Do we as a realtor have to? Because if we give an application to a landlord, they say no. We have no information as to why the no is, they just said no.
I'm dealing with a case right now, okay, where a woman has sued a combination of realtors and brokerages for discrimination based on family status and creed, ethnic origin. She was told no. Just no. Okay? And this is just something, a word to the wise. Okay? I can't tell you how to defeat legislation. It's just not something I can do. But I want you to just think about it from this perspective. I know that my client's reasoning for not renting the unit to her was that she works as a professor at a university and was only going to be staying in the house 3 days a week. And my client said, well, what happens if a pipe bursts? What happens if something, it's going to take her 4 days to discover that there's a problem in the unit? And who knows how much the cost of that damage would be by the time she discovers it. That's the conversations between the realtor and my client. But they chose to just tell her no. Now it's in front of the Human Rights Tribunal. This woman's not willing to settle for anything less than $30,000 because no. It's going to go all the way to hearing, where she will most likely lose. My clients have to date spent $10,000 on legal fees. They will probably spend another $5,000 on legal fees by the time they get to the hearing to ultimately be successful. And it's the Human Rights Tribunal. So that's money that they might as well have just taken out of their pocket and lit it on fire. They will never get it back. There will be no cost to it. So if you want to use the simple no, or if you want to not tell them, that's up to you. But understand there's no vetting process when somebody files a claim. No court will say, yeah, we're not accepting that. Okay? The person who processes your claim, the people who process your claim, they have no right to interfere with the filing of it. Okay? So, if it gets filed, you're defending it. Plain and simple. Also, at the HRTO, there is a layer of protection where an adjudicator does review the claims and says, prior to you having to give a response, you must provide me submissions in writing if you want this to move forward. But the submissions in writing aren't to determine whether or not the person has a case. The submissions in writing is to determine if there are issues that can be dealt with at trial. So, a simple refusal is an issue to be dealt with at trial based on evidence and based on testimony of the parties.
But you could do everything right, not discriminate at all, and they still file something. You're
Sure.
still gonna get pulled into this, you're still gonna have the legal fees anyway.
Absolutely. But wouldn't you rather have the legal fees with proper documentation to prove that you did not discriminate?
Does she not become responsible for the legal fees at all?
No, not a human rights tribunal.
No.
Only in extreme cases of vexatious litigation. And vexatious doesn't mean, well, you lost, so it was vexatious. Vexatious just means, like this woman who brings 25 claims to the HRTO, that could be determined to be vexatious. But just bringing a claim because you felt you were discriminated against and you happen to have lost because you weren't, that doesn't generate a cost award most of the time.
And are there professional human right people that keep doing this regular?
Sure.
Like, are there? Do we have? Does this start to come around?
Sure.
Is there a
Yeah.
list?
There's also people who regularly slip and fall at supermarkets and sue for slip and falls. People are going to be people. I mean, whether we like it or not, 80 of us are pretty great, 20% of us not so much. Right? I mean, you know, and I mean, I always tell people, I love stupidity in principle. It's going to put my kids through university.
But now, does the court look at somebody who's professionally doing this, and do they ever, like you said, she's got 25 cases in? Does the
If
court
they're
look at it?
legitimate cases.
But if
I don't
if she
like-
just lost the one against you, how are they legitimate?
Well, that one is not resolved
For
yet.
example, right? Yeah.
But the issue is, was the ad discriminatory? Yes or no? Based on her circumstances, was it discriminatory? Yes or no? Remember what I said at the beginning of my presentation. The ad doesn't have to, the person doesn't have to apply to have been discriminated against. They just have to feel like they couldn't apply. And if I'm an ODSP recipient and I'm making $1,500 a month, and you're advertising a unit for $1,400 and you say must provide employment letter, I'm on ODSP. You're never going to accept me based on your ad.
I love ODSP tenants. It's guaranteed rent.
But that's not the point, right? Right? And it's not, but that's besides the point. So, a lack of rental history may be related to a code ground. For example, recent immigrants, refugees may have a lack of Canadian rental history. A man or woman may be attempting to reestablish themselves after a marital breakdown and may find themselves in a similar situation. Landlords are strongly encouraged not to treat the lack of rental history as an equivalent to a negative credit history. Doing so could place you in violation of the code ground. If a prospective tenant lacks a rental history for reasons related to a code ground, landlords should begin looking at other available information on the prospective tenant and make a bona fide assessment. It's possible that some prospective tenants identified by code grounds may be likely to have lived in rooming houses or have lived in past residences for short periods of time. So what that means is this: if I am a refugee and I have freshly landed in Canada, I have no Canadian history. Chances are, if I'm a refugee, the place that I fled is not going to be kind enough to provide me with my credit report in that country. Okay? If it even exists. So what else do you look at? History, like employment history or source of income history. You look at, do they have family? Is there somebody who has an available cosigner? Something we'll get into later. Have they got any Canadian credit whatsoever since they landed? I mean, I know RBC gives like a $500 refugee credit card without any credit history or checks of any kind to establish. So have they got something like that? Are they paying it on time? Are there anything? Are they paying their monthly payments on time? Those are things that would allow you to give a bona fide assessment. Other than simply saying, "Oh, you have no credit history, therefore I'm not going to consider you." Right? That could be discrimination based on the circumstances of the person applying. Now, if they've been in Canada a year and they've already defaulted on 7 credit cards and that's a negative credit history. You can deny based on that. It's only if they have no credit history or are new to Canada that you want to consider outside forces. Right? We'll also get into this later in the presentation, but this is also something that has severely affected women. Right? They're going through a divorce. Maybe they were a homemaker prior or they worked in an income prior. They've now gotten divorced. Their credit ratings dropped 150 points. They're in a bad financial situation. Maybe they're fleeing abusive relationships. Maybe they're simply leaving a relationship that they don't want to be a part of. And a landlord will look at that negative credit history, do no searching, do no investigation as to other methods to verify that this person would be a good tenant, and they just simply decline them based on credit. That would be a discrimination based on family status. Right? Takeaway from this, ask for other sources of information.
Can I
Right.
ask a question?
Sorry,
Sure.
back in your example a few minutes ago when you said that the woman was away from the property for 3 days a week and the landlord didn't like the sound of that,
Mhm.
so that person was told no. If they had been told no because we need somebody on site, would that have been sufficient?
No, it wouldn't have been discrimination at all at that point. You as a landlord don't lose your ability to make a decision to rent to a tenant simply based on the Human Rights Code. You still have law of property, and you still have law of equity, and you have all these other things that play into your decision making as a landlord. The claim probably never would have been filed had somebody just communicated and said, the reason we're declining your application is because you're not going to be in the property 4 days a week, and my clients aren't happy with that.
And if the person said, it's okay, I'll have my brother come over or something like that, then you could carry.
Well, then you could explore various circumstances,
It's just
right?
not a
Do
flat
do
no.
I, as a landlord, want to have somebody who's not even on the lease staying at the property 4 days a week alone? Is that an assignment of a tenancy? How do I know she's moving back in? How do I know she's not renting it for her brother? There are other decisions that could go into it, but at that point, the idea of the discrimination is gone. It's vacated,
Okay,
right?
so you can, yeah, so
Right.
you can apply that to other things as well.
That's right.
Yeah.
And also, you know, in the same situation, if she had wrote back and said, I don't know what my realtor told you, but that's not the case at all. This is going to be my full-time residence. I'm going to be changing my driver's license over. My commute's only 45 minutes each way. That's nothing. I'm going to do that every day. And cleared up that misconception, because she was the perfect tenant other than those 4 days that she was away. That would have cleared up that problem as opposed to a simple no, and nobody would have spent any legal fees because the situation would have
Gotcha.
resolved itself.
Thank you.
Yeah, but then now the landlord says, well, I still don't feel right with this. So then they refuse.
Look, in this particular case,
Yeah.
they were refused because they weren't going to be in the property 4 days a week. There could be 1,000 what if scenarios that we could discuss. You know, what if my mom dressed like my dad? Like, it doesn't matter, right? Like, we can discuss these ad item.
But 99% of the time right now, again, we're dealing with a lot of renters right now, right? They're coming in and I'm being honest. I'm saying no to everybody just by speaking to them because we already know what we're looking for. And that's because, again, the landlord has experience, he knows what he's looking for. So what can we say that's neutrally correct that A, we don't have to justify it and we don't expose ourselves? Like, what is a simple answer you can give that doesn't come back and bite you?
Well,
or
again, I'm not going to give specific legal advice,
Yeah.
okay? You have an obligation to make an ad as neutral as possible. How you choose to screen your tenants is up to you.
Okay.
If that ends up coming back to an HRTO complaint,
Yeah.
you better make sure that your screening process wasn't discriminatory.
Okay. And then as when you have a client, you give them a list of questions to ask if
Well, look, you're a professional, right?
yeah.
Okay. So when you're doing your intake for your clients,
Yeah.
and your client says, "I want to know that they make $150,000 a year, and I want to know that they have an 800+ beacon score, and I want to know that they can do all of these things." This is where you, as the realtor, have to communicate to your client and say, "Listen, you may want these things, and we can certainly look for these things, but we have to screen appropriately, and we have to screen in a way that doesn't put you at risk of a human rights complaint."
Or you.
Right?
Yeah.
Okay, so what would be the problem of saying I want an 800+ beacon, other than the fact that these people should be homeowners and you should be having a completely different discussion with them?
But we're not even getting there.
Right.
We're trying to figure out who's going to be living in the house, and right at that point, we're shutting it down.
But the point is that if I can cover my rent, and I'm not going to create problems for you as the landlord, and your sole reason for declining me is my kids, you have to understand that that's a risk, and you need to explain to your client that's a risk, and they need to outweigh that. Would you rather have a lawyer in the basement who complains because he heard the 3-year-old running the tricycle down the hallway, which is just normal part of living, and he lives in a basement apartment, so what does he expect to begin with? Or would you rather deal with the $15,000-$20,000 plus award damages and legal fees because you chose to not do kids in a 3-bedroom house? Right? You have to weigh that decision. I can't tell you the right answer. Your client may say, I'll burn 50K on that, I don't care. Right? This lawyer's a good lawyer, he's been there 12 years. I'm willing to take the hit to keep him happy. Okay. Right?
Good question. So as long as you explain and your ad's good, that's gonna be on the landlord if it goes to court.
So like I said before, the courts don't look at things when something's filed and say, oh, this person shouldn't be part of the claim. You may very well end up on the claim regardless.
Even if you did everything right.
Right, even if you did everything right. But you will at least be able to prove that you did everything right. Okay? Ultimately, it's your client's decision. Right? You just need to prove that you did everything right. Okay?
May I add something?
Sure.
CYA, have we spoken about that before?
Not here, but go ahead.
Okay, so what I always say is to myself, good morning, Charlotte. Always, whatever you have to say to yourself before you start your day. And I always say CYA. CYA, and it just resonates with me throughout the day. And I tell all my students, one of the first things I teach them is CYA. Cover your assets, right? So always remember that. So if you wanted to make sure that you said everything to your client, right? Landlord, potential landlord, put it in writing. What you say to them, put it in writing, exactly as Dan is saying, right? CYA. So always remember that. That
I'll
may
get
help.
clients pretty quick.
We always like to say if it's not in writing, it never happened. Right? So I'm sure you guys have dealt with lawyers and they'll send you an email 5 seconds after you get off the call and they'll say, just to confirm our conversation.
Yeah.
I advise you of this, and this, and you chose to go like this. That's what they're doing. How to evaluate employment history. So, some landlords place requirement that a potential tenant have a stable, long-term employment. This requirement can be a problem with people identified by several code grounds. For example, a requirement for employment history can or is likely to have an adverse effect on women who have taken time out of the workforce to raise children, provide caregiving or others, for others, or who are otherwise trying to establish and support themselves independently. I mean, I suppose I can say for men as well, but I mean, just see women are still the large majority of child rearers over men, so that's certainly something that can be discriminatory. Such requirements could also affect new Canadians, people with disabilities who are unable to work, people who receive social assistance, including older people who receive CPP and OAS, seasonal workers, young people starting out will have a shorter employment history. While the code allows the landlord to ask for income, it does not allow a landlord to ask about employment history when deciding if they should rent to a prospective tenant. The HRT has found that it's a violation of the code. Now, let me clear again, just to clarify. There is nothing wrong with asking for employment income or employment history or proof of income, which is the much better statement to use, proof of income, after you have said, credit checks out, everything checks out, I want to move forward with this person and offer them a tenancy, I just need to verify their proof of income. That is not discriminatory. If they hand you a pay stub or a T4 or a notice of assessment after that's done, that's not discriminatory because you've already made the decision to rent to them based on all the other factors. However, if the reverse is true and you just say, oh, this person's on CPP and OAS, pass, let's move on. And you don't check their credit, and you don't check their references, and you don't check anything else, that is discriminatory based on receiving public funds. Okay? So, take away from this, employment history is just one part of the puzzle. You have to have the whole puzzle. So, if a tenant's receiving social assistance, this would be discrimination based on the receipt of public funds. It's also not legal to request a person receiving public assistance to be subject to a request if not required by all potential tenants. Even if the request is required by other applicants, it could still be discriminatory. I'm not going to go into Garbutt and Fisher. Let me sum it up this way. If you are renting a basement apartment, and you have two tenants that have a 680 credit score, and they both make $2,000 a month, and the only difference between the two of them is that one guy works at Canadian Tire for minimum wage and one guy gets ODSP, and you choose to go with the employment guy at Canadian Tire for the sole reason that he works at Canadian Tire, that can be discriminatory.
Can you just say it was a better?
Well, why is it better though? If they make the same amount of money and if they have similar or same credit scores and they're similar age and they say, why is it a better
What if you
decision?
choose the other one?
I can get fired.
I can say you hate Canadian
I
Tire.
could sue you for
Yeah.
Well,
discrimination.
they couldn't because the Canadian Tire guy is not in receipt of public funds. Not to mention the Canadian Tire guy can be fired tomorrow.
Yeah, but also he's not at home as much, so the wear and tear.
How do you know that?
Well, if he's working until even a minimum 20 hours.
So if I'm disabled
Yeah,
and I require crutches to get around,
you're staying
that-
home. You're not moving
that's a
nowhere.
negative thing?
No. But you asked. Then you said it's human rights.
I mean, you gotta remember, this person's on ODSP. ODSP is not an easy system to get onto.
No,
Yeah,
it's not.
Okay, so if he's on ODSP, that means that he has some form of mental or physical disability that prohibits him from being able to work.
Yeah.
So you're saying, well, he's gonna be home more. So that's why I wrote it, so is that still not discrimination?
No, but then you went to the human rights and you said that there's other laws, which is real property. I think you said there's other forms of law that also kick in, right? So now you got two applicants, identical applicants. Then you go back. Then again, you're peeling the onion backwards, right? You're trying to see, okay, who's going to be home less? Who's going to be using
Why
the
do
utility?
you care who's gonna be?
I'm the landlord.
So what?
So that's wear and tear
They're
on my
not
property.
slaves, they're your tenants.
No, but that's wear and tear on my property. That's usage if I'm providing utilities. That's cost on my utilities, right? Then next year when the market rents have gone up $500, this guy's stuck at $1,100. Then now the landlord and tenant board is holding me against the wall. I can't do nothing. I can't raise up his rent. I can't kick him
So
out.
what's the difference in the guy creating
But it's
tire?
as the whole picture. So when it comes back to, you said, so if they're identical profiles, why would you pick one over the other, right? So when you go
You know what?
backwards,
I wanna stop for a moment.
yeah,
And we're gonna pretend that I'm the legal representative of this fictitious tenant. And we're at a human rights tribunal of Ontario case.
but let's take that out for a
Hold
second.
on,
Let's look
hold
at
on.
the situation.
And I'm cross-examining you.
Yeah. Oh, I have my lawyer. I wouldn't be
Hold-
speaking.
No, you would be, and I would be cross-examining
Yeah.
you. Okay? So I wanna let's do this in 5 or 6 questions, let's be short. Sir, do you agree with me that you had 2 applications for this rental property?
Yes,
And you agree with me that both applicants had a similar credit score?
correct.
And you agree with me that both applicants were similar of age?
Correct.
And you agree that both applicants were men?
Correct.
And you agree with me that the only difference between the 2 applications is that one worked at Canadian Tire and one was on ODSP, is that correct?
Correct.
And you agree with me that the reason that you chose not to rent this unit
Yep.
was because the person on ODSP would be home more, is that correct?
Sure.
Well, yes or no, is
Yeah.
that correct?
Yeah.
Okay, and so you acknowledge the fact that you chose to make a decision based on this person being home more, is that correct?
Sure.
And you agree with me that if someone's on ODSP, they have other physical disabilities, is that correct?
Sure.
Or mental disabilities, is
Absolutely.
that correct? So what you're effectively telling this court is that regardless of the receipt of social public funds, you chose to choose a tenant who was not physically or mentally disabled, is that correct?
But you said they must have some form of disability.
Sir.
So we don't know what to what.
I'm
form.
asking you a yes or no question.
Sure.
So you're saying today
Yep.
that aside from the ODSP issue, which is discrimination on its own,
Yep.
you also chose to rent to somebody who's not disabled, correct?
Sure. If you want to word it like that, absolutely.
Okay.
If that's the way you're wording it, but then at that point, again,
Perfect.
It's a
now,
matter
now,
of going to court.
now I'm going to say thank you.
Yeah, and I lost.
I'm
your
going to
point of
sit
view.
down,
Yeah.
and my client's going to get a $30,000 check from me.
Sure, I understand where you're coming from because you're cornering me into a position, right?
But that's what's going to happen.
That is going to
That's
happen,
exactly
but
what's
then
going
I
to
will also
happen.
have a chance to prove my case.
You've already
Oh,
spoken.
no, you've already admitted
Well, I'll
it.
let my lawyer then deal
Yeah.
with it. Like I wouldn't be the one speaking.
Oh my
I would
goodness.
let them. But what I'm saying is, I understand where you're coming from, discrimination and stuff. And the chances are, I may even pick the Canadian Tire guy who's making a little bit less money just because of the problem, if they have a mental health issue, it's creating more of a problem on the,
It doesn't matter. Nothing you're saying
That's
matters.
discrimination though.
I don't see it as discrimination, I just maybe have to find a better way to word it.
But how do you
Yeah, but you
choose
have to
then?
answer
Like,
their yes or no.
Yeah.
Sure, but then I will have my lawyer as well that will also
But
do
your
a
lawyer's already
cross-examination.
asked you your questions.
Your
And
lawyer
he
can
voted-
save you from
he
yourself.
he would have guided me already, so I would have a better way of answering that
But
question.
your lawyer can't, it's a yes or no question.
Yeah.
How is your lawyer gonna guide you to better answer a yes or no
Yes or no
question?
question.
I don't even know how you would redirect that.
Again, right now I'm not
What's your
prepared for this, but I'm just in the
bag?
heat of the moment, and
I
I'm saying.
guarantee you will never be prepared for cross-examination.
Sure.
If it's done properly, it doesn't matter how much preparation you've done,
Okay.
okay? It's not a shot at you,
Yeah.
okay? Nobody's prepared for it. Because you're gonna get somebody like me who does it 20 times a month.
Yeah.
And I can ask you anything. I can ask you what your favorite ice cream is.
Yeah.
I don't even have to ask my questions based on the testimony you gave. I can ask you questions that are completely unrelated to the testimony.
Sure, I understand that.
Okay, and I'll ask you yes or no questions.
Yeah.
And when you try and elaborate, I'm gonna say, sir, please, yes or no. And you're gonna try and elaborate again, and the judge is gonna say to you, sir, it's a yes or no question, just answer it yes or no.
Sure. Like I said, I would speak to a lawyer before I would come, and right now you're more prepared than I am, so you put me in the corner, so
I'm not
you
prepared,
win,
I
no
just
problem.
learned the scenario 30 seconds ago with you.
But what I'm saying is, again, if you look at the whole picture, I think there should be, or there must be a way to protect us as a landlord, because we're not being discriminative when we're not putting somebody in there. It also says in the landlord and tenant board to let the individual use that space without interfering, right? Or letting them have peace in their place, something along those lines. So if I'm not putting somebody in there with kids because there's somebody downstairs that's gonna have a noise complaint every day, then I have to call upstairs, regardless of whether it's normal noise or not.
The question is,
Then it's me saying, then it's me lying to
So,
the new tenant that's
first of all,
coming in
what
because
did
I
I
didn't give
say?
them that information.
at the beginning of this presentation, what did
Yeah.
I say? I said the Human Rights Code of Ontario is quasi-constitutional legislation.
Sure.
It overrides every other piece of Ontario statutes. Okay? It is second only to the Constitution of Canada. So when you go to a human rights tribunal, you're not gonna be able to say, but the Residential Tenancies Act says that I have to give this guy quiet enjoyment.
Yeah.
You're going to have to show how it was an accommodation to the point of undue hardship that you refused a person with children because of the person in the basement. And undue hardship, remember what I said, costs, outside sources of funding, or any social and health and safety issues.
But
So could you as a landlord have remedied the situation by putting down carpet instead of hardwood floor?
they didn't want carpet.
Doesn't matter whether they want to.
The new tenant didn't want carpet. They came into the place because it had hardwood.
Okay, can you soundproof it?
Sure, at whose expense?
Yours. Duty to accommodate to the point of undue hardship.
Okay. So that's my response. So then I can go around pretty much nailing every landlord in the city then, is what you're telling me.
Some of them.
Yeah, pretty much. Why do you think we're so busy?
Yeah, but that's what you're pretty much indirectly telling me. I can go around, I can
I'm
just,
not indirectly, what I'm indirectly telling you, I'm not indirectly telling you.
the system is telling me this.
I'm telling you directly what the law is. I'm telling you directly how it's decided. Remember, as I said at the beginning of this presentation, none of this is my opinion. This is based off the Ontario Human Rights Code and several white papers on landlords' duties to accommodate and landlords' duties in regards to advertising. This is not my opinion.
So then, how much would you say that landlords know about what you're talking about? Would you
I
say-
do this presentation for landlords on a regular basis.
Do you?
I do this, my other presentation that I'm doing next week to landlords on a regular basis. I would say 80% of the people who get into this business don't understand that landlording is a business,
I understand.
Yeah.
right?
Yeah.
Most people get into it and just think, oh, I'm gonna get this passive residual income every month. And then a tenant doesn't pay rent, or they do something like this, and then it completely kills the investment, right? All this presentation should be doing is showing
In the
you,
middle of a meeting, can you call me back?
all this presentation should do is show you that what's really important here is record keeping. Record keeping and showing your decision. If you end up making a discriminatory decision, that's deemed to be discrimination, that's something you're just going to have to deal with. Okay?
Sorry, how do you choose them? Because everything can be discrimination.
Yeah.
Not everything.
I'm not saying me, I'm saying the landlord. He has the right to choose whoever's gonna live in his house, right?
As long as the reason for choosing is not discriminatory.
Okay, so he can say, I like that person better.
That's what I'm saying. I just opened a business.
I'm going to get into this more through the presentation. I'm actually like not even halfway through because you keep stopping. But
I'm just trying to understand, like.
so let's use the example of the Canadian Tire versus the guy in ODSB. Okay. At that point, what you should be doing as a landlord is deciding who's the best fit for you. Okay? If the guy has tattoos all over his face and arms and has a nose ring, think he might be a party guy? Think he might be a guy who likes to party a little bit? Okay, that could be a decision. There's no such thing as discrimination based off tattoos.
No?
But that's the biggest.
No.
Well, you could,
So
it could be
So-
marginalized, or, I don't know, I'm just saying.
marginalized doesn't mean tattoos. Marginalized means it's a black tenant versus a white tenant. Okay? It doesn't mean tattoos. So what are the other key factors that might cause you to determine one tenant over another that aren't discriminatory? There's many things that you can do to determine a good tenant that doesn't have to be discriminatory on its face. Right? If you have somebody who calls you up and says, is the apartment available? Yes, it is. And they say, great, and my name is, and it's a Sri Lankan name, and all of a sudden you're like, I meant, sorry, not available.
I'm just saying, you get everybody, you go through all the process, you document everything, but ultimately it's the landlord's decision to choose.
You're right.
Right?
All you need to worry about is your records.
Okay.
The email to the landlord that says, if this is the person that you want to go with, I respect your decision, I'm going to make sure they're in the unit. I've already discussed with you that I believe that this decision may have some repercussions. You've chosen to go through with it anyway. Your job is done now. Okay? So, how do we evaluate a credit report? Okay? A landlord is permitted to request credit references and to conduct credit checks with permission of prospective tenants. They may consider this information in selecting or refusing a tenant. A landlord should be aware that a requirement for a credit check may have an adverse effect of people by code grounds. For example, women returning to the workforce after lengthy periods of caregiving, marital breakdown. The Human Rights Tribunal is the practice of refusing applicants with little or no credit may have a disproportionate impact on code grounds. Doesn't say it's necessarily discrimination, it just says that it may have an impact. Even with a bad credit rating, there may be extenuating circumstances relating to the code ground that should be examined before rejecting the person. Again, single mom, 2 kids, her credit's taking a tank because of the divorce. You want to explore other things that may have an issue. In all cases, credit history must only be considered as part of a bona fide attempt to validly assess potential tenants. So, I saw an ad very similar to the one that I had at the beginning, where they said applicants with under a 775 beacon score need not apply. Those were the exact words. Okay? Is that a bona fide attempt to assess the tenant? If that's the only thing you're looking for? Right? So, again, if your client's instructions are, I want 750 plus, 775 plus, 800 plus, there is a way to do that without being discriminatory. Don't put it in the ad. Right? As part of an application process, I'm sure other agents provide you with a copy of the Equifax report that has a beacon score. I hope after the application process is done, you are running your own credit checks, and we'll get into that in the other presentation. But screen it that way. If somebody comes to you with a 650 beacon or a 670 beacon and their income's not that great and they're missing some credit card payments, you have no obligation to take that person on simply because they have they've submitted an application to you. It just doesn't meet your landlord's criteria and you move forward, right? As long as you are evaluating it as a total part of the solution, right? So they've supplied references, they supplied an employment letter, they've proven income sufficient to cover rent. Your credit score is not just that great. So now you talk to your client, you say, look, here are these other factors. You know, what do you think? No, I still want to go with 800. Okay, fine. Send an email to your client. I sent you this application and we've decided you chose to move forward with something else. That's your job. That's all you have to do, right? If that person comes back and says you discriminated against me based on my credit score, they would have to prove that that was the reason that you discriminated against them, in the sense that if there was no communication, you didn't know what ethnic background they had, if you didn't know what how many children they had, if you didn't know what religion they practice.
But what if that was the only thing why, that's the only reason why they weren't successful, is because their credit score was low. But they had good references, they have a decent job, it's just their credit score was like 500 and
Again, why is it 500? That's what matters, right? If it's 500 because they've defaulted and had a car repossessed, you're under no obligation to take that person on. If they have a 500 because she just got out of an abusive relationship where her abusive ex controlled 100% of the money, had all the credit, and then when she left, he stuck her with $100,000 of debt, you have to ask.
Okay, and at that point, it's okay for us to ask, not us, but like.
Yeah, I wouldn't say, hey, can you tell, I wouldn't say, look.
Yeah, like why is your credit score this
But
high?
inquire. Listen, my clients would like to understand why your beacon score is so low.
Now, if you can see the default, can you say, well, listen, we notice in your credit score there's some default here.
Right.
And therefore we've decided to move
That's right.
on.
But at that point, if you've got two applicants and one's got a great credit score and the other one doesn't, can't you just say to the one with the low credit, we've selected a tenant who has a better credit?
So remember we talked about applications?
Yeah.
If you have the same information for both people,
No, it's quite different. You have the same information, but the one that you like has a better credit score.
right, but I'm trying to explain that to you.
Okay.
So if you've created a neutral application process where you don't know anything about kids, where you don't know anything about anything other than income and credit score, and you just make the decision based on a credit score and you know nothing else, you're fine.
Okay.
Now, in our, job on a daily basis, we're submitting offers to rent, right?
Right.
And there's 4 other offers, and we just get a notice that they decided to work with somebody else.
Well, look, at that point, I would say, if your client says, oh, this is discrimination and blah, blah, just step away. Let your client deal with it however they want to deal with it.
Okay.
Right? The worst mistake you can make as a realtor is start going, yeah, I agree. You should have gotten this place. I don't know what happened. Right? Because not just to mention the fact that now you're going to be at least a witness in whatever action they bring. Whereas you just say, look, in tough market, we submitted the app, didn't go through, let's just move on to the next place. Well, why do you think they turned me down? I don't know, we can investigate that after. Let's focus on getting you the place that you need to live in first.
That's just what I did.
Right? Like, if there was something else, we'll deal with it later. Right? All you have to do is just move on from it. And again, nothing here is an exact science. Right? This may not happen. This may happen to 99.9999% of realtors may never have this issue. Right? But once is usually enough. Right? Going through it one time is enough. Most people don't want to go through it a second or a third or a fourth. And if I can help you avoid it to begin with, just by keeping records and making smart decisions and realizing when you're having conversations with people that you might want to temper what you're saying,
Especially when you're the listing agent. right?
especially when you're the listing agent, then I've done my job, right? Hopefully none of, whether you think this is, for lack of a better term, whether you think this is all bullshit or not, right? It at least protects you. Okay? So, we talked about credit history. Grounds to refuse a rental unit, a landlord may request credit references and rental history or both, and may refuse based on their results. This is important. A landlord may request information from a prospective tenant only if the landlord has also requested a credit check or rental history. Okay? If after requesting the information, the landlord's only provided the income portion, the landlord may consider the income information alone in order to assess the prospective tenant, and the landlord may select or refuse the prospective tenant accordingly. A landlord may only use the information to determine a tenant has an income, but is not allowed to judge the source of the income. And a landlord cannot use a ratio to determine a tenant's worthiness. They may only consider that the tenant receives an amount sufficient to pay rent and cannot consider what their non-housing expenses are. This was determined in kvCore in Ontario. Okay? So you are not allowed to arbitrarily say rent should only be 30% of my prospective tenant's income. Okay? This is really about less expensive units. I don't think you're going to have the same issue with more expensive units, simply because the people applying for it probably are making sufficient income to cover it and all their expenses, and they're doing their own equation in their head. But if you're renting out a basement apartment for $600 a month, and the tenant shows that they make $600 a month, you can't say, oh no, sorry, you need to make $1,200 a month minimum for me to consider you for this bachelor apartment at $600 a month.
I don't think they have any apartments for $600.
No, I'm using it as an example, right? I'm using it as an example, but you understand the point. So also where this is important is this type of discrimination typically impacts lower income earners and people who are on some form of government assistance. If you're renting a 5-bedroom, 5,000 square foot house for $10,000 a month, you're probably not running into this problem, right? So just something to keep in mind, again, something for the back. A landlord can ask for a guarantor, and a landlord may refuse to rent to tenants who own animals if the animal is not a service animal. Okay? So you know on the application, do you have any pets? If the person checks the yes button, the next question should be, can you tell us a little bit about your pet? Is it a service animal? Do you have a prescription for it? If it is, it's not a pet, it's a service animal. When I talk about guarantors, guarantors would be, could be considered discriminatory if somebody in the same circumstances would not be required to give you a guarantor. So if we go back to this Canadian Tire versus ODSP example, they both have good credit, or they both have similar credit, not necessarily good credit, they both have similar credit, they both earn roughly the same amount of money. If you ask the person who has ODSP for a guarantor, but not the person who works at Canadian Tire, that's discriminatory, because all things being equal, the only difference between the two is that one is in receipt of public funds. And like I said before, the guy at Canadian Tire can get fired tomorrow, right? So it would be really hard to justify a cosigner in one versus the other scenario. Of course, they would have to prove that you didn't ask anybody else for a cosigner, which is another thing altogether. But this is what the code says, so I'm passing it on to you.
But as long as you, like if you do and you keep documentation, it's all good, right?
Yeah. Now, in a place like Toronto, I have this presentation, I'm happy to send it to you.
I think some of us are thinking we have appointments. Sorry, I wasn't, that was
It-
very rude of me.
Oh, no, it wasn't rude at all. It's fine. I get it. Like I said, I was in sales for 20 years. I get it completely. If you have an appointment, go make money. Best of luck to you. Right? Instead of listening to me, I'm totally fine with that. Okay. The only other thing I'll talk about are deposits. We'll see a lot of offers to lease come in where they've said the tenant agrees to pay 6 or 7 or 8 or 9 months rent in advance. If the reason, we can get into the legalities of a deposit in my RTA presentation that I'm going to do for you a little bit down the road. If the sole reason for the deposit was because somebody is new to Canada and doesn't have established credit, that could be seen as discriminatory. Right? And when people say, oh, but they voluntarily gave it is not, we're turning you down because you have no credit. And then they come back and say, well, we'll give you this 6 months. And you say, okay, fine, with 6 months, we're willing to do it. That's not voluntary. Voluntary would be the first offer comes in. On the first offer, they indicate they're willing to prepay 6 months to, as a reason. And you would have rented to them anyway, even if they hadn't agreed, but you chose to take the deposit because they offered it voluntarily. So in other words, there was no horse trading, right?
As a realtor, if you suggest to your clients to make that offer, is that considered discriminatory in any way?
No, listen, again, there's a reality of life that isn't always reflected in case law and legislation. If you as a realtor say, hey, are you in a position to offer a little bit more, not just because you are a new immigrant with no Canadian credit history, but because you'll be one of 30 people who are bidding on this property.
Okay.
Right?
Right.
And maybe 3 or 4 months or 5 months of rent up front may put you at an advantage over the other 29 people who are also trying to get into this property. That's not discriminatory. That's just you talking about the market in its current condition, trying to help somebody get a leg up. Right? If the landlord comes back and says, the only way we'll consider your application is with a 6-month deposit, that's another story that you would have to take on a case-by-case basis. That's where you would call me up and say, hey Dan, I've got this issue, or hey Victoria, hey Sharda, I've got this issue, can you tell me what I should do? While the landlord is permitted to, okay, I already covered this. Security deposits, extra requirements, we talked about this. In-person meetings. In-person meetings, again, they're an inevitable part of your business. You can't talk around them. I would caution everybody that there are now things called text messages and emails and Facebook messages and other mediums in which you connect and talk to other tenants, to prospective tenants. If, and this is a case that I actually know of because I'm working on it, landlord has several conversations with my client. My client's voice is a neutral voice, meaning it doesn't identify any particular creed or religion or some other way of determining their race. On the phone, oh, I can't wait to see you, it's gonna be great, blah, blah, blah. My client's black. My client's attended a meeting with the landlord. 5 minutes later, she gets a call and says, yeah, we're not interested, we rented it to somebody else. 5 minutes after she walked out the door. She took them to the board, and the landlord said, no, we offered it to the first person who we spoke to. We didn't think that it was right to offer it to the second when the first person said they wanted it. Well, through text messages and emails and social media, the mediator, it hasn't gone to hearing yet, but the mediator basically told the landlord, look, you're full of shit. She checked all the boxes. You told her she checked all the boxes. You told her the meeting was more of just something you wanted to do to get to know the tenant who's going to be moving in. You effectively offered her the units and had seen, and then you meet her and you find out she's black and also the unit's not available anymore.
And then what happened? How much it was?
It's ongoing.
Still ongoing. Because actually I had a client. We put an offer and then just like I called the listing agent. I said like, why did you reject the offer? And she said, I said why? Because she's black. And she said yes. Yeah, I said like, yeah, my client actually had a black tenant before and they had a bad experience. I said, but people are not the same.
Well,
and then
you weren't here when I said it.
Yeah.
But there's this app that you can download called ACR, Automatic
Yeah.
Call Recorder, that allows you to record those types of phone calls on your phone, and you don't need consent from the other party in order to record.
Okay.
In order to record, because we're in a first-party consent country.
Mhm.
So something like that you may want to keep on record.
yeah.
Okay.
Yeah.
Wow.
Okay. Notice I'm not surprised.
True.
Right.
Flat out say that, it's true.
If there's multiple applications coming in, just be prepared to talk about how you chose the applicant. And you should keep all that information for 12 months. I'm gonna skip this part because I covered in my other presentation as well.
I have experienced a lot of discrimination against age.
Mm-hmm.
And how do you even, like, they will flat out say that they don't want that person because they're really young.
Well, again, you might wanna have ACR or something that allows you to keep track of that, right? I have business cards on the desk here if anybody wants them. If not, my contact information is on the screen.
Thank you.
Yeah.
Sharda and Victoria are both paralegals from my office, as I said before. Feel free to speak with them and get their extensions and talk to them. To be honest with you, if you have questions, they are the best people to speak with. I literally litigate 20 days a month. Julio and I worked quite hard to find dates that I'm actually available. Luckily, I had 2 Tuesdays available this month. That's not the occasion, that's not the norm. So if you need fast response, you definitely want to reach out to Sharda or to Victoria, because they will give you fast response.
Can you tell
So
them?
are you gonna put their information up next?
No, they were a later addition, but if you want, when I send the presentation, what I'll do is I'll send the presentation by PDF to Julio. And on Julio, the email I sent to Julio, I will put their contact information in that email. And then when he forwards the email to anybody who wants the presentation, then you will now have their contact information.
Thank you.
Can you just talk about the next presentation, which is next Tuesday?
So the next presentation, which is next week, is going to be my top 10 landlord and tenant board issues. They are the top 10 landlord and tenant board issues that my firm personally sees, as opposed to some list that we pulled off of Google. And it's going to talk about forms, how they're used, when they should be used, and what to deal with when it comes to the forms. The realtors, obviously, if you deal with landlords, when there's a problem with the renter, they call you, they don't necessarily call us. We want to give you a strong foundation to understand which forms can be used and how they can be used, so that when the form, when the client does come to us or another paralegal, they've done the right thing, more really, and also to ensure that the information you have is correct. So we'll talk about another case called the Rivera case, which actually said there was a lot of confusion of who could serve notices and how they would serve notices, and whether it had to be a lawyer or the landlord themselves. Well, the Rivera case came out that said you as a real estate agent can assist a client by giving notices to a tenant if that's something that you want to do, if it's in a property management capacity. Whether you want to do it, whether your insurance will cover you if something goes sideways, that's another story altogether. But we found overwhelmingly a lot of realtors are assisting their clients, so we want to make sure that you have good information so that when you're providing it to your clients, it's accurate. So that's all. I really appreciate you all coming today.
Thank you.
We're
Thank
gonna
you.
hang out, if it's okay with Julio, we'll hang out for a little while and answer any questions that you guys may have one-on-one. I know that this was a lot of information to take in a very short period of time, but we're hoping that we at least gave you some tips to help better equip you to deal with residential leasing.
Thank you very much.
Good question. So you have a property, and maybe you listed it too low.